in the matter of EAV and GMP 2021.
Yes, good morning, Miss Naik and Lord Murray and Miss Lewitt too, and everybody. We've had an opportunity to read quite well into this case, so we've got a good grasp of the issues, we hope. We've read the decision, or your excellent skeleton arguments, and the decisions of the court below. We've had a chance to think about some of the case law. It occurs to us this case is listed for a day and a half. We're hopeful it won't take as long as that. We think that it ought to be manageable within a day, but we wonder what your thoughts are about that and whether you've had a chance to discuss between you how the time's going to be divided up.
I'm very grateful, my lords, my lady, for that. We have had a proposal based on the full-time estimate. That was only I can see the slight disappointment in the court's response to that. It may be that we can take it shorter, depending on obviously how much I need to go into the trafficking legal framework, for example. It did occur to me yesterday in particular that we might be able to take it shorter, and perhaps the best way to decide is to see how it goes. Yeah. But to be fair to Lord Murray, perhaps I should be indicating that I should be, hopefully we'll be able to finish my case just after lunch. I wouldn't want to commit to try and finishing it before lunch, depending on...
Well, of course, it depends how much we interrupt, as always.
Yes, I mean,
anyway, we think we have a broad idea of the framework, but it will be helpful, I think, for you to
I'm conscious that this is a statutory appeal, and that therefore the issues in terms of the focus of the legal errors are may be described as narrow, but in order to the broad proposition that we have is that in order to understand the nature of those errors, it is important to understand the trafficking background and how that interacts with the Refugee Convention arguments. And so,
right.
But I can see that...
Well, let's get started.
Yes, thank you. And just for those purposes, we've done introductions.
Yes.
I just wanted to confirm about the bundles everybody has, that the court should have a core bundle in each case,
yeah,
a supplementary bundle in each case, yes, and an authorities bundle.
Yeah.
Yes.
And those an amended grant of permission.
Yes.
It was.
I think it just Christopher Floyd's name was added.
Yes, that's correct.
Was there any other amendment?
No, that's correct.
I've got your up-to-date skeletons,
which was
separately, and we've also had a letter from the government legal department about GMP's human rights claim.
Yes, and so the short point is that appeal that she has been stayed, yeah, and the invitation has been to stay it behind this appeal. And it's perhaps important at the outset to remind the court that in both appeals, that the sole question in the appeal was the entitlement to Refugee Convention protection, because of their human rights claims were going to be dealt with separately, either at appeal or in the case of EAV pending.
Right. I'm actually thinking there wasn't an alternative claim to humanitarian protection.
That's right. Yes, so it's focused solely on under the Refugee Convention.
We haven't heard from the FTT as to whether the...
Oh, I see. The FTT hasn't confirmed that the appeal is stayed, but I think if both parties want that to be the case, then I couldn't imagine there being difficulty with that.
And just before you develop your arguments, in a matter of interest, I noticed that one of them has had discretionary leave. What's the immigration status at the moment of the two appellants?
Yes, so both appellants are here, by the way, sitting back in court. In EAV, she has leave to remain on the basis of continuation under Section 3C of the Immigration Act 71.
Yes.
Because she's got a pending human rights claim,
yes,
waiting determination following the grant of leave on the basis of being a trafficking victim.
Right.
And in GMP's case, she also had a previous period of leave on the basis
I
of being.
noticed she had a discretionary period that expired in 24. I just wondered if
Yes,
it'd
she made a human rights claim in time.
be- right.
Her leave is also extended by virtue of that, but she has been refused, but she's pending an appeal. So the important point for the court is that neither of them are overstayers, they're here lawfully.
No.
And importantly, as we say when we come to look at the case, they were in the UK because they were brought here, obviously by their employers. So it's not perhaps what might be described as the usual type of scenario dealing with a refugee claim. So I just like to just briefly, I will be conscious of what I've heard from the court in terms of the pre-reading, try to condense my submissions down, but effectively just dealing with the issues in summary, overview of how the Refugee Convention interacts with the Trafficking Protocol, because we say that is how the error arose in relation to both the FTT and the UT in their respective cases. Take you to the legal materials. I can give you the references if we don't need to go through them in great detail. And then the structure of how the persecution arises through the UNHCR trafficking guidelines, and then what's common ground, and then effectively what isn't. Coming to the core question, which is what they would do on return, what the individuals would do on return, and the legal analysis by reference to the three cases that we've cited in our skeleton argument, particularly the RMED, HJRT, and then coming back to the approach of the individual cases. So individual tribunals. So that's the sort of the roadmap, and I.
Thank you. Very helpful.
Thank you. So just to confirm, obviously in opening, these two appeals concern the linked appeals for women who are trafficked from the Philippines to the Middle East and then to the UK. And it's obviously really important that there's a recognition that the trafficking started in the Philippines, and that both of them have been accepted by the Secretary of State's Home Department as victims of trafficking. And although and that the method of recruitment took place in the Philippines, although they've obviously escaped that persecution, their claim is that they are unable to return because of a well-founded fear of persecution. That they say they have no alternative because nothing has changed in their personal circumstances, and that they would seek further employment overseas in order to secure their and their family's economic survival. And that's how they articulated their claim. So the central question arising in the appeals is whether they are entitled to the protection of the Refugee Convention in circumstances where they would act in a manner which would put them at real risk of further trafficking. Instead, as their tribunals have articulated it, of being obliged to act in order to avoid the risk. That was effectively the summary ratio of the tribunals. And obviously the question for the court is that the interpretation of the Refugee Convention is one for this court. There isn't any other sort of supranational court to assist with that. So we then look at effectively what of the construction exercise is on the text of the Refugee Convention, as the senior courts have looked at it over the past in the history of the long established cases. Just coming back to the facts as to whether the appellants are entitled to protection under the Refugee Convention, in EAV's case, just to remind the court, the first tier tribunal said yes and allowed her appeal against the refusal of the asylum claim, accepting that the same factors that previously existed that pushed her to employment abroad, which resulted in her being deceived into domestic servitude, are still present. That's at paragraph 15 and 16 of the EAV determination. FTT, sorry, that's core
Paragraphs
bundle.
15 and 16.
Yeah, core bundle EAV 59. The first tier tribunal, there was a real possibility that EAV would seek employment abroad because she's got no realistic alternative in the Philippines to securing her family's economic survival. That's 16 and 18. And in circumstances where the illegal recruitment practices are still prevalent and involve government officials or non-state agents from whom the state cannot protect. There was the unchallenged trafficking expert evidence from Professor Siddle, and that we don't have to go there, but it's in the supplementary bundle at tab 5, pages 29 to 40. And therefore, the first tier tribunal found there was her fear of a real risk of further exploitation was well founded. That's at paragraph 20, C60 of the core bundle in her case. And in GMP's case, the first tier tribunal found that she would not, using the words, endanger herself by seeking work abroad. That's paragraphs 58 of her core bundle, 64 to 65. That any further risk of re-trafficking would arise from her choice to go abroad, and that was that was said to take her outside the protection of the Refugee Convention, which is the conclusion of the first tier at 54, paragraph 54, I should say. So as the upper tribunal in GMP upheld that approach, and in EAV, the upper tribunal took the same approach in both finding the error of law in the first tier and then remaking the decision. That's at 24 and 25 of the upper tribunal.
In granting permission to GMP to appeal, Lord Justice Popwell and Sir Christopher Floyd made certain observations about the difficulties of succeeding on given the factual findings.
That's in relation to GMP.
To GMP,
yes.
No doubt you'll be coming back to that.
We will, but in order to make good the argument, I do want to set out why both appellants are entitled as a matter of principle under the Refugee Convention, and then look at whether the findings of fact are supportable against that background. But it's right to say that in EAV, the first error that's alleged in relation to the upper tribunal in her case, which is set out at ground 3 of the grounds of appeal to this court, are that the upper tribunal should not have interfered with the first tier for the reasons that they gave. In relation to GMP, that the upper tribunal was wrong not to find that the first tier was entitled to reach that conclusion, that it was a question of the choice that she wouldn't make, that she wouldn't endanger herself.
So wrong, not. I think there were too many nots in that.
Sorry, in EAV.
I got EAV, but on GMP.
The GMP, that the upper tribunal was wrong in failing to identify that the first tier tribunal had similarly erred in law by their construction of the question, that it was still a choice, that she wouldn't endanger herself by seeking work abroad, and that she wasn't, that the first tier tribunal wasn't entitled to make the findings of fact that they did with that construction question in mind.
It's a straightforward fact finding. She would not have sought work abroad. Whatever the reason for it, doesn't matter. It's a fact finding. She would not do it.
My lady, when I develop the submissions, and I will take them in a more narrowly focused way, but we have set out in our skeleton argument in detail. One of the core findings in GMP, I'll come back to this, is that she would not endanger herself. So what the first tier tribunal judge was seeking to do was to emphasise that the appellant, there was an element of what was she reasonably permitted to do, because her evidence to the first tier tribunal was that she would seek work abroad, and in part a key part of the first tier tribunal's reasoning in GMP was that it wouldn't be effectively reasonable for her to endanger herself, and that is the way.
Well, we flagged a
Yes.
point that we are interested in
Yes.
on that, so no doubt you'll
Indeed.
look at that carefully when we come to that point in your submissions.
Thank you.
Yes.
So just coming back to the structure of what each appellant had to show in order to come within the Refugee Convention, the appellant has established that she's got a subjective fear of persecution, which is for reason of membership of a particular social group here, former victims of trafficking, and I'll come back to that. The fear is objectively well-founded and that she's unable to avail herself of state protection. That's the Refugee Convention definition. You don't have to go there, but
Just
it-
define again precisely the PSG that you're alleging.
yes. So what was the accepted PSG in EAV was former victim of trafficking, and I accept that in the case of GMP, the Secretary of State articulated in the decision letter that that a potential victim of trafficking was not a member of a particular social group. But when it came to the first tier tribunal determination, the case, we say, has proceeded on the basis that she was by then accepted to be a former victim of trafficking, hence the
But why does that make her a member of a PSG as defined?
it's that we say that it's the Secretary of State accepted in EAV that she was a former victim of trafficking.
Forget what the Secretary of State accepted. Why does it make her a member of a PSG?
So we say, and I've got some further arguments developed in relation to this, which I would like to come, and I
Yeah.
hope that that's unsurprisingly a matter that the court wants to hear from us on. But that is that as a former victim of trafficking, the characteristics that led a woman in the Philippines, and it may be that the way in which the PSG needs to be more clearly articulated is that a woman in the Philippines of poor economic circumstances, or somebody who is a low skilled labourer, who is the head of a household. These are all characteristics which led her to be
Yeah.
trafficked, and that therefore these are the reasons why the Secretary of State has accepted that both women have got very similar situational histories, that a former victim of trafficking is a member of a particular social group, and it's for those reasons that the Secretary of State accepted it in the EAV.
Has the group got anything to do with the fact that you've been trafficked once, or is it you base it simply on the economic circumstances?
My lord, we don't. It's not the case. We accept that the appellant is going, either appellant is going to be trafficked by the same person
No,
or
forget the
persons.
same
So that
people, yeah.
so it is that her circumstances, which led her to be trafficked in the first place, which were her poor economic circumstances, lack of skilled labour. That she's only able to do unskilled labour, and that they're both heads of households. Women.
It's got
heads
nothing
of
to do with the fact that she's been trafficked once and is therefore likely to be trafficked again. It's simply that she's part of a larger economic group, which effectively becomes a lot of people within the Philippines.
It's when we say simply, first of all, we say that for the purpose of these appeals, which when they were before the tribunals, in particular the upper tribunal, the question of how the PSG was defined wasn't an issue. And so if the court wants that, we haven't developed our arguments in relation to how that PSG should be defined or more broadly. And in fact, if that's a question that the court is concerned about to determine the question of the error, then it might well be the case that in fact those issues do need to go back to the tribunal for further.
Sorry, Ms. Nake. In order to be able to show that somebody falls within the Refugee Convention, given that they're not dealing with a defined characteristic, it has to be shown that they fall within a PSG. We need to know what that PSG is in order to be able to determine whether or not there was an error of law in deciding that they weren't entitled to refugee status. It's as simple as that.
But my lady, I totally understand that. But it is also right to say that when the appeals proceeded, the question of what was the PSG was accepted by the Secretary of State in EAV, and it went through the first tier and the upper tier without any question about what was the particular social group. And in GMP, although there was a question raised by the Secretary of State, it also was not, there was no challenge to the question in the first tier tribunal or the upper tribunal, reminding the court, as I did, that these were only Refugee Convention appeals. So that was the core question.
Well, we've raised another point
Yes.
which you want to look at,
I
which
hear
is
that.
which is to look at this this PSG category that is at the centre of this case, and I think we want to look at it irrespective of how it's been considered hitherto
I-
either by the tribunals or by the
I
Secretary
will
of
come to
State.
that. I just observe that those were submissions made by the Secretary of State in their supplementary skeleton, I think it was, to the Commission judges, and then in her current skeleton argument. But there is no cross appeal or question that's been raised by the Secretary of State in a formal context of this statutory appeal that there is no particular social group. That if there have been, then we would be here, that would be front and centre of the way in which these appeals are prosecuted before this court, in particular defending the upper tribunal, the first tier tribunal in EAV. And so if the court does want to go down that route, then I'm ready to
Okay,
answer
well,
some of those
I think
questions.
we will want to hear submissions on that.
Thank you.
And you can include at that stage, develop the points
Yeah.
you've just made about the point not having been taken hitherto.
Yes,
Right.
thank you. So the starting point is what has been accepted in both cases, and that is that the appellants have a subjective fear of persecution on return to the Philippines, which is by reason of being returning as a former victim of trafficking. I'll come back to the way in which we articulate the PSG, and that the Secretary of State accepts that if they were returned and if each appellant did seek employment abroad, she would be at real risk of further persecutory harm in the form of trafficking, from which the state is unable to protect her. Those are really critical parts of the what has been accepted. So just for the court to note, and I think it's important that I remind you there that in EAV, at page 39, core bundle, page 39, paragraph 24.
Yes.
That you can see at the end of the remaking the decision, third sentence, if she returns to the Philippines due to poor economic circumstances, she might decide to work again, go abroad again, because the work is better paid than the work she'd find in the Philippines. If the claimant chose to work as a domestic worker in the Middle East, she would face a real risk of suffering the same treatment she previously suffered. So we say that that is an important context in which the court has to examine this question, so that, and that's in addition to, and you don't have to necessarily go there because I've already articulated it in my opening, but at paragraph 18 in the first tier in EAV, the FTC finds there's a real possibility she would find work abroad again. So that finding is clear that there would be a risk of serious harm if she were to undertake seeking work abroad again.
I mean, I don't want to keep interrupting you, Ms. Nathan, but I don't think one can look at the last sentence of 24 in isolation without then going on to look at the that few lines of 25. So that
Yes,
is,
so that is of course how we articulate what the challenge of our case is, that whilst it's reasonably likely the claimant would only be able to obtain low employment in the Philippines, we don't consider this or difficult economic circumstances are capable of mounting to persecution within the Refugee Convention, because it goes back to the question of deciding to leave. But the key question about risk, for the purpose of our argument, is that it arises, and it is accepted to be, that there would be a real risk of suffering the same treatment that she previously suffered. And that, whilst I totally accept what's said in 25, in 24, I'm just trying to narrow what the issues are on the facts of these cases, and then come to how those, what the core question between us is. So that's on EAV. And in GMP, again in the upper tribunal, the it's paragraph.
So this is
In
GMP,
GMP, just again.
core bundle.
Core bundle. Paragraph 13, which is at page 41. 40, sorry, 40. The upper tribunal judge, deputy upper tribunal judge says this appeal ultimately comes down to two simple points. Firstly, whether the appellant will be driven by force of circumstances to work in the Middle East to contribute towards the support of her two remaining minor children and one adult disabled child. The parties agreed that if the appellant were to seek work overseas, there was a reasonable likelihood of modern slavery / re-trafficking. So that's the basis upon which we've prepared these appeals, is on the narrow focus of what has been accepted, unsurprisingly. Now, the Secretary of State didn't accept that that would be a act because the part and the tribunal in EAV and the first tier upper tribunal in EAV and the first tier tribunal in GMP concluded this would be an act of their own free will, and in the second case, that one that she in GMP would not undertake because it would be endangering herself. And that was the basis of how, that's the conclusion that we are here, that we challenge as being a misdirection in law. And we say that the definition of trafficking, which is the interlinked act between the means of recruitment by deception and the fraud and abuse of their poverty and economic vulnerability, which is in the Philippines, that then causes the risk of resulting in actual exploitation for the purpose of domestic servitude.
Would you just say that again?
In the third country, my
Because I
lord,
think
yes.
that seems to be at the heart of your case
It
in
is.
response. So
It
can I
is.
do?
So we say that the conclusion of the tribunal, those that we just articulated, is a misdirection in law as to the definition of trafficking in particular, because trafficking is a series of interlinked acts by means of recruitment by deception or fraud or abuse of their position of poverty and economic vulnerability.
Recruitment by deception.
Or fraud and abuse of their position of poverty and economic vulnerability, which occurs in the Philippines, that then may result in actual exploitation for the purpose of domestic servitude that takes place in the third country. And so when we come to the definition of trafficking, it's the act, which is the recruitment. Sorry, it's the
operative act is the deception, isn't it?
yes, it's the deception which occurs in the Philippines. Then it's the transfer to the third country, and the purpose being the
But without the
exploitation.
deception in the first place, you wouldn't be getting it.
Without the deception in the first place.
In this
That's right.
case, how it won't in both these cases. Obviously, unlike some other types of trafficking, obviously, once you're forewarned about that, is this deception still operative?
Well, my lord, we say that it is, because it's not
The
every.
economic situation, I appreciate, is exactly the same.
But we say that if a person walks into a recruitment agency, which you're perfectly entitled to do to look for a job, you're then looking for employment, and that when one could either be offered a job that is real and that is the job that the person thought they were hoping to undertake, which is a servant, or it could be one where there is the person's going to be deceived by the agency into a form of enslavement by virtue of, and those were both of the past experiences of these appellants were precisely those. The deception took place in the Philippines. It could have been a legitimate employment, but it wasn't.
No.
And so that the deception, the act was there. The transportation then took place in terms of both the agents then assisted with the facilitation of the appellants to the third country, get their visas and so on, and then for the purpose of the exploitation which then took place.
Why, forgive me, this is it seems a superficial question, but why is it, how does it follow that if someone has been deceived in the past in certain circumstances, they will be deceived, there is a risk of deception again?
Well, my lord, I'll come to. I'm accumulating the questions, but we say, and totally appropriately, of course, and we have been anticipating those.
Yeah.
But we say that applying the Refugee Convention case law, which we've cited in our skeleton argument, in particular the relevance of past persecution, that creates that is the starting point for identifying that there would be a real risk in the future for this particular character, for this particular individuals. I think the counter to that, which is the Secretary of State's position, is that if you have suffered persecution in the past, you're less likely to suffer it in the future. That's very contrary to the principles under the Refugee Convention that have been articulated in the case law that I'll come back to.
I mean, just to flag up the point, and I don't want to.
Yeah.
So forgive me, Ms. Naik, but I think it's important that you
Yeah.
have. Is it the persecution or the deception that has to be established is going to recur?
We have to.
Deception.
We have to establish that the persecution, there's a real risk of persecution as a whole. I'm just going to come on to what those how those
The persecution is a result of the deception. I mean, your position is that the trafficking has to be seen as a holistic thing.
yes.
So the fact that the persecution will take place in a different country is neither here nor there, because you say the risk of it occurs endemically in the Philippines. I get all of that.
Well, yes.
What at the moment is bothering me is why you can say that any of that is on account of their membership of a particular social group.
My lady, I will come back to the particular social.
Well, I think, and I've been as guilty of more than any of us. I think we should just let you develop the arguments now, but you can see the issues that we're.
Of course, we see those.
I don't think they take you by surprise.
They don't. If I, with respect, I'm obviously that conscious of how I need to put my case. But just to come back to my Lady Sandru's point, we don't say the persecution takes place in the third country, because we say that because of the trafficking definition, which I'll come to, is the three
And
elements.
the deception is part of the persecution.
That the deception is part of the trafficking, and trafficking as a whole is the persecution.
All
So
right.
that's why we say that the persecutory act starts in the Philippines.
Okay, right.
I think that's important. And just when I was coming back to the first point about the interlinked acts, and we've just dealt with that first point about the misdirection law and as to the definition of trafficking, and the second point was the irrelevance of consent in those circumstances, and I will come back to developing that argument. But that's, we say, a misapplication of the law on the accepted facts and evidence about their particular experiences and vulnerabilities of victims of trafficking and their membership of a particular social group as former victims of trafficking. I totally accept. I have to come back to answer my lady's point, but in order to answer it, it's not a one-line answer, so I will need to develop.
Well, that's why I think we should let you develop it in
how that
in the way that
arises,
you
yes.
choose.
Yes. And so we say that the court obviously will have to examine the interaction. Just to, we've seen the grant of permissions. I don't need to go there. So we say that there were the three in both cases. There were three interrelated errors about in finding the appellant's free will or choice which takes them outside the protection of the Trafficking Convention, even if, as we've identified, it leads to the risk of further trafficking. The first error was that the tribunals failed to grapple with the legal relevance of the appellant's past persecution, a point that Lord Justice Baker has already identified, which was on the accepted evidence occurred not only because of deceptive recruitment practices, but also because the state was unable to protect them from those practices. And we say that on the unchallenged objective country evidence before the tribunal, that remains the case. And I will develop, just to flag later, the references to the Secretary of State's CPIN and the Trafficking in Persons report. But as we've already identified, the way I've put my case is that that future risk and lack of state protection was accepted in those passages I've taken you to, your lordship and my lady too, in the those two determinations. The second error was in relation to the definition of trafficking, i.e. the question of it being irrespective that it's a victim's choice or consent, a decision to seek employment abroad because of poverty or insecurity. That is the context in which the abuse by the traffickers takes place, because she's deceived into believing that a proper job or a good job awaits her rather than the intended exploitation. Then that is trafficking. And in that context, for the purpose of EAV in particular, the tribunal was wrong to say that that risk only arose outside of the Philippines. As I've just identified, we're talking about the recruitment being the act, the means of deception, and the intended exploitation all occur in the Philippines by the employment agency. That, as a matter of fact and law, constitutes trafficking. And so the upper tribunal in EAV, at paragraph 5, was clearly wrong to say that the first tier tribunal had erred in law, and that this, if you perhaps you just might want to just go there, because it's just
Core bundle EV,
core bundle EV, paragraph 5, which is at page 37. And this comes back to the comes back to the question about targeting, which I'll come to in a moment. But the paragraph 5, the third sentence, at paragraph 18, the judge found that it was not likely the claimant would be targeted in the Philippines. And so the question of relocation or sufficiency was not the issue, that it risk rose out of
economic necessity.
Out of economic necessity. Importantly, because it was part of the Secretary of State's grounds of appeal to the upper tribunal in EAV, that because she wasn't targeted, therefore she wouldn't be at risk. But in fact, it's important that I think my Lord Justice Jeremy Baker had this point, which is that she's not saying she would be personally targeted. She's saying that because of her membership of a particular social group, women in the Philippines, former victims of trafficking, we'll come back to, she would be at risk on account of that reason, because of the intention of the traffickers, who are in recruitment agencies. Their intention is to deceive, lure, perhaps is another word, women in those circumstances into effectively into economic slavery. That's
their intention is to deceive any woman in any circumstance of poverty into economic slavery, whether they've been the victim of trafficking beforehand or not.
Well, my lady, that may be the case. That doesn't mean that the appellants cannot make good their appeals under the Refugee Convention on the accepted facts that they have. It should make it, in fact, easier for them, which is the purpose of us referring back to their history of trafficking, because that past history, we say, makes it more straightforward to demonstrate future risk on account of that status. And I'll come back to that question, because it's a building block question which I need to go to in order. I think it's the best way to do it. The third error, just coming to the summary of how the errors, is that where each appellant is clear that she would seek further employment abroad, because on their factual case they both said they feel or they have no alternative. That's not a choice. It's a question of facts, and I totally understand. I have to come back to address how the tribunal's approach to the facts on GMP, but they have to get there by a rational and lawful route. So it's not legally and factually relevant, we say, whether it's objectively reasonable or unreasonable. It's a question of fact. And secondly, and most importantly, if she would suffer a real risk of persecution in that context, then she's entitled to the protection of the Refugee Convention. But importantly, the upper tribunal in EAV were legally wrong to find it was a choice, and that was out with the protection of the Refugee Convention. And in GMP, the first tier tribunal and then the upper tribunal were wrong to say that she wouldn't do that in order to avoid the risk of persecution. And we say that's not a conclusion that was open to them legally or factually, because when we look at the arguments for it that arise in the context of, as we've developed in our skeleton argument, and I'll come to those in a moment, HJ Iran, and concealment or RT Zimbabwe, about not doing that which is reasonable, it is open to seek employment.
Isn't that that's the type of case where you're living your life in the country itself, and surely you shouldn't be living a lie to your innate characteristics.
I mean, I accept that we totally accept there isn't an authority which we can take you to that will land us home. We have to, which is why we're in this court. We have to build the argument about why.
You're drawing an analogy.
From HJ Iran.
From HJ Iran and
the-
from RT,
Okay.
which is that there's the individual appellants are entitled to seek employment as any in relation to not. This is not about trying to get a better job abroad. This is about about economic survival, and that is an important consideration when looking at an entitlement to protection, rather than just thinking about. So it is not the same as the identity question in HJ Iran or the political opinion position in RT, but it is analogous, we say, to a woman in poor economic circumstances who's previously been the victim of trafficking, to say, my factual circumstances are that I will seek employment abroad. I will approach a recruitment agency, and if they are targeting women in my position, and I am going to be that person, then I'm entitled to the protection of the Refugee Convention. This is not a floodgates point, as it was always argued in HJ Iran that would mean that every gay man in Iran would come to the UK and claim asylum. That is not the scenario that has occurred or that we have seen.
Well, you've anticipated precisely what I was going to put to you. Professor Seidel says there's 12 million people in extensive poverty in the Philippines. 10 million estimated working overseas, 53% as migrant workers in the Middle East. If every woman who is in extreme poverty in the Philippines is driven to going to these agencies to work to the Middle East, and they're all at equal risk of being trafficked, whether they've been trafficked before or not, it is a floodgates argument, because on your analysis, every single one of them would be a member of a group who would be targeted on account of their vulnerability.
My lady, that was exactly the scenario, or not exactly, that was the type of argument that was posited before the Supreme Court of House of Lords in HJ about how many potential gay men in Iran there might be who seek to come to the UK. The actual analysis in a statutory appeal under the Refugee Convention is, first of all, those persons have to be here in order to claim asylum. And critically, and I opened with this point because it is a really important part of how we present our case, that the reason the appellants are in the UK lawfully now is because they were brought here by their traffickers, by those who exploited them and brought them here, and they were able to escape after some years of being in that exploitation. So factually, the numbers of people women, because we're dealing with women victims of trafficking, who would be able to claim asylum and make good their claim in order to show that they're at real risk of persecution. It's not that they're just potential victims of trafficking. Factually, to make good an asylum claim, they have to show what their personal characteristics are, what they would actually do, come back to the question of whether the facts finding in GMP was correctly arrived at or not. And in this case, or both these cases, the accepted history by the Secretary of State is that they've both been recruited, transported and exploited in that trafficking definition. And so this is not, when properly understood and applied in the individual context, a floodgates argument. Similarly, in the Shah and Islam scenario, women in Pakistan, will every woman in Pakistan who doesn't want to be married suddenly decide that she's going to come into the UK and claim asylum? No. This was a way to frame the Refugee Convention argument about women who were in the UK seeking to resist removal on the basis of a fear of persecution, and how to define that within the Refugee Convention. And so I totally understand my Lady Justice Andrews' concerns, and we have anticipated them, and I hope to be able to develop it when I look back at look through those. I will go through the authorities. There's only 3 or 4 that we need to look at, and that will be the way in which we answer that point.
Right.
But the Secretary of State says these appellants effectively are economic migrants. They are not. They didn't migrate to the UK. They were brought under duress. They were trafficked, and they resist their removal to their country of origin because of the accepted risk of what will occur to them on return. And the only question is why it will occur, and whether this is really on account of their voluntary action. They will seek legitimate work abroad, and the risk arises from that. So that's why we say that they're entitled to the protection of the Refugee Convention. I just wondered whether it was worth going to, as I said, we need to look at the interaction between the Refugee Convention and the human trafficking. Is it worth going to the definition of the Refugee Convention, which is, so if we can go to the authorities bundle now.
Tab 1.
And so it should be page 3 that
Recitals.
that
Preamble.
oh yes, sorry, page 4 I think that should be.
Page 4. Definition of refugee.
That's right. And so the elements are those in highlight. Owing to a well-founded fear of persecution.
Sorry, highlights. did you say?
Sorry, apologies, sidelined. I've highlighted my copy. It's Article 1A2.
Yes.
Owing to a well-founded fear, so well-founded is a subjective fear that is objectively justified, that by reasons of
being persecuted.
Of being persecuted.
For reasons of.
For reasons of. And then for here, we're dealing with the question of membership of a particular social group.
So the persecution has to have a causal connection with the attribution.
It does. And that's why we say that it may be that if the particular social group, say we all, just to repeat, sorry for repeating myself, but because the PSG was in these appeals went through on the basis of former victim of trafficking, and that was never the subject of the appeal, nor any sort of, as I say, question or cross appeal from the Secretary of State. In these statutory appeals, it hasn't been addressed further than former victim of trafficking because it was accepted, and that's not the reason. They have to
be persecuted because they are a former victim.
That's not the reason. With respect, that the upper tribunal in EAV dismissed the appeal. They didn't dismiss the appeal because they didn't find she was a member of a particular social group. They said she would face re-trafficking if she went abroad, but it was a question of choice. And in order to understand whether there's a causal link between the act of seeking of working abroad or seeking work abroad and whether that is in fact persecution, then that was the focus of the upper tribunal.
Let's just assume, sorry to break it down. There has to be persecution. You say trafficking starting in the Philippines amounts to persecution.
Yes.
Right, that's fine. The persecution as defined has to be for reasons of membership of the social group. All right? So let's assume that the membership of the social group is as defined before the upper tribunal and the lower tribunal, which is somebody who has previously been trafficked, right? Or a woman who has been previously trafficked. So you have to show that there is a well-founded fear of being trafficked, persecuted, because they were a member of that particular group. In other words, somebody who has been trafficked before.
my lady, what I will come
Don't you?
to develop that. What we say, because it went through without.
Well, first of all, do you agree or disagree? Because this is your opportunity. Am I reading the convention wrong?
No, my lady, reading the convention right, but the definition of the particular social group, and it was put in GMP, for example, I won't take you there now, was put in it may be a broader PS particular
Alright,
social
well,
group of women in the Philippines or women in poor economic circumstance in the Philippines. And you'll see from when we look at the authorities of Fauna and Shah that even in the House of Lords, and the Supreme Court, their lordships define the social group differently, in relation to women or women in Pakistan or women who'd contravened social mores. There was a lively, what I might describe as a lively debate between their lordships on that. And so, as long as you are a member of a particular social group,
isn't it rather important to define what the social group
Yes.
is? Surely.
my lord, I agree that it shouldn't be that it is important to define it. It's just that in these appeals, that it wasn't an issue in EAV particularly, which is the start, and actually in GMP.
Probably wasn't enough focus on that part of it.
And I think I could accept that there wasn't a sufficient focus on the question of the PSG by the tribunals in these cases, and that
You see, it seems to me that you've got to go one way or the other. Either you say the particular social group was defined, nobody's ever argued anything differently, and it was defined as being somebody who was a former victim of trafficking. And that is the social group that we're dealing with. And so we have to ask, is there a well-founded fear of being trafficked, persecuted, because they were trafficked before? Because they are a member of that particular class. That's one way of looking at it. The other way of looking at it is, well, whatever was said before, the particular social group is a wider social group which involves consideration of poverty, economic circumstances, etc., etc. And then you have to ask a slightly different question: is there a fear of them being trafficked because of that? So until we actually nail down what the particular social group is that you are contending for, we can't answer the question.
Well, my lady, I agree with both of those propositions. It's the reason I haven't nailed my colours to the mast so far is because in the upper tribunal and in the first tier tribunal, in both cases, the question of particular social group was effectively dealt with by way of former victims of trafficking, and that the risk question wasn't agreed or disagreed because of whether they were a member or not a member of the group. The risk question was, we accept all of the profile questions. The reason we don't accept that you're at risk of trafficking, there was a sole question in both cases, which is, you're choosing to do this, and that is not out with the protection of the Refugee Convention. So I hear my lady's concerns, and I have a sort of fallback argument, if I may, and I may develop that, which is that it was posited, particularly in GMP, in the alternative wider argument about particular social group, which was women in the Philippines in poor economic circumstances, or uneducated or low skilled, those factors. It comes back to the point I've already made about floodgates, which is no, because we're looking at the risk of persecution has to be made good with reference to factual, with not only characteristics, i.e. potential victim of trafficking, but actual, how do you evaluate the risk of harm? And in these cases, on their particular facts, it was by reference to their history of trafficking, which had made them vulnerable to abuse. And that's why I think there is, in my submission, a connection between a former victim of trafficking who can demonstrate quite clearly that they have the characteristics of vulnerability.
The characteristics are independent of the fact that you've been trafficked, aren't they?
They're not the characteristics.
Maybe more easy to
they
share.
are linked to the fact of being trafficked, because they were trafficked. Sorry to.
No. I'm sorry for interrupting you. This is very difficult.
It is.
And
I would say that's why I was hesitant about the time estimate, because there's quite a lot of complexity.
I'm sorry, I committed the cardinal mistake of interrupting you when you were answering my Lord's
I just
question.
wanted to finish that last
Please do. Forgive me.
thread, which is that their personal characteristics of economic vulnerability and those personal circumstances are what led them to be, when the traffickers have people who they're thinking, the traffickers are targeting people, but it's a larger group, it's not an individual. They're the ones committing the act, and they will look at a group. I think the women who are economically vulnerable and have a pressure on them to in these circumstances can demonstrate, as this is all that the hypothesis of what has already been accepted, pressure on them to support their families. Those are the characteristics that then led them to being trafficked, and then hence they are former victims of trafficking.
Okay.
That's why there is an interlink with the characteristics, my lady, which is why I'm not avoiding the question. I'm just trying to expand on what I think, how I support.
Can I just read Miss Lou's note and then I'll ask you my
yes.
question. So my question, do you want to make Miss Lou's comment or?
She invites me, of course, quite correctly, to take you to the trafficking definition, which I will do.
Good do. Well do. Well, can I just be clear on this? It may well be you say this is an irrelevant question or you've already answered it. Are all previous victims of trafficking members of this particular social group, or is it only a narrower cohort of previous victims of trafficking?
Well, one doesn't have to be every person who is in the definition of a particular social group doesn't have to have been persecuted or at risk of persecution. They just have to show that every person within the cohort doesn't have to be persecuted in order to form a particular social group. They just have to be susceptible to persecution. And we would say...
no, sorry, that doesn't work.
That's Lord Roger in Fauna at paragraph.
Well, maybe we need to go on to the authorities, but can I just follow up my am I asking the wrong question? I mean, obviously there are a lot of victims, sadly, tragically, a lot of people who are ex-victims of trafficking, of this sort of trafficking. Are all of them in this particular social group, or is there some other factor which has to be taken into account, such as economic circumstances, for them to fall into the group?
Well,
or is that the wrong
I mean,
question?
how we define the social group, I mean, there are lots of different ways in which to define it, but for our purposes, we're talking about former victims of trafficking from the Philippines. We can define it as former women victims of trafficking from the Philippines, because that is the group that we are concerned
You say
with.
that's a recognised social group in the Philippines?
In order to, I mean, that is one way of
It
defining
has to be a recognised social group in the society, in the country in which one's dealing with. So there has to be a recognition that former female victims of trafficking generally is a specific social group.
I mean, my lady, what we would say is that allied to that definition, and this is about the characteristics of all the women in that group, we would submit are economic vulnerability and vulnerability to abuse and because of their poor economic circumstances. So that may be another way of defining it. And
well, I think this is quite important, if I may say so, because hypothetically at least, there will be women who were trafficked on whom life has looked more favourably. They've married a rich man or whatever.
My lord,
So are they nonetheless still in a particular social group?
On one analysis, yes, because they wouldn't be claiming asylum. And back to my point that the Lord Roger makes in Fauna, and I'll have to take you to Fauna
Yes,
in a moment,
please do.
which is that not everybody in the social group has to have been persecuted, but they do have to be susceptible.
They have to be at risk.
Okay.
And so if the person who had married somebody rich or whatever the scenario was going to be returned to the Philippines, she has to be outside, if she were going to make a refugee convention claim, she'd have to be outside her country of origin at risk of persecution because of that reason, but she wouldn't be outside her country of origin for that
So
reason.
is the social group therefore women who were formerly trafficked and are at risk of being trafficked in the future? Is that
Yes.
is that the how the group is defined?
That's sorry. I was just looking at the note. I will take you to the trafficking definition and the fauna analysis.
Okay, well,
if I can just park that
let's
question
park that point.
until we've gone through the definitions.
All right.
okay, right. So that's Article 1.
Yes.
Where do
So
we go
what I was
next?
going to perhaps for these
Trafficking definition.
purposes, just before we get to the trafficking definition, was to take you just to the explanatory note to the ECAT. Just explains why trafficking in human beings, what the problems of it are, and why it exists, why the protection against trafficking exists. So if we just go there first, so that is at
Tab 4.
Tab 4. Sorry, mate.
ECAT's Council of Europe Convention on Action Against
That's
Trafficking.
right. And this is the explanatory report. And for these, if I can just take you to paragraph 75. Bear with me one moment.
Right, on page 49.
So, sorry, just bear with me one moment. I think might have the wrong page for my.
It might be 73 and 74, which talk about the definition.
Oh yeah, so it starts at page 36. Sorry, and then
Basic
it goes.
components,
Yes,
etc.
Which is
Well, 75 is the key one, isn't it?
That's what
It's a
that's what you
combination
said,
of the constituents, not the constituents taken in isolation. That's
Okay,
your
so it's
point.
actually, sorry, if I just, before I go to the definition, actually my reference and my note was wrong. I just wanted to remind the court, just going back to absolutely paragraph 1 of this report, which is at page 36. Sorry, my
Okay.
was wrong. Which is just to emphasise the context of trafficking in human beings as a major problem in Europe. Paragraph 1. It's largely women and children who are the victims. You see that in paragraph 1. It's paragraph 3. It's either labour or the sex trade. There are two different aspects there. Paragraph 3. And working for a pittance or nothing at all. And important to note at paragraph 7, the distinction between trafficking and smuggling of migrants, which again we're not concerned with. That's at paragraph 7 of that document. And then now we can go down to paragraph 43, which is at page 42. Bear with me. Which is that, and this is all feeds into the recognition, to the definition of persecution when we get there. The recognition is at 42. The recognition of trafficking in human beings as a violation of human rights appears directly or indirectly as a number of international instruments and declarations again, and that in paragraph 3 specifically talks about enslavement, although yes, I see 43C, which means the exercise of any or all of the powers attaching to the rights of ownership over a person, including the exercise of such power in the course of trafficking in persons, in particular women and children. And then this is just setting the scene that in paragraph 46, the main added value of the present convention in relation to other international instruments is its human rights perspective and its focus on victim protection. And that's, we say, is important when we're looking at its intersection with the Refugee Convention. And then at paragraph 52,
Yeah.
purpose of the convention, which is to prevent and combat trafficking, to protect the human rights of victims of trafficking, which is designing a comprehensive framework for the protection and assistance of victims, and the principle of non-discrimination. I just lost the reference for that, but I can find that for you in a moment.
Somewhere in 45, isn't
And
it?
then
54. rather.
yes, and that's right. And then at 50,
Sorry. forgot.
57,
Mhm.
the two mains of the aim of this convention are the protection of the rights of trafficked persons and the prosecution of those responsible for trafficking. And so then we come down to 77, which is at a
Well, for me, it would help.
to get,
Again, I'm the slowest ship in the convoy. To go to 73, 74, 75.
yes. So let's go to the definition there, which is the definition. 71 is say the definition of trafficking human beings is not the first definition. Here we go. 73, 72, to combat trafficking more effectively and help its victims is fundamental importance to use a definition of trafficking human beings, which is international consensus. The definition 74 is
Combination.
of that's
three
right, a
basic
combination with three basic components: the action of recruitment, transportation, transfer, harbouring, or receipt of person. So here we're talking about in the Philippines, the recruitment and the transfer or transportation. And importantly, when we come to look at the facts, if we can just hold that, was that in the conclusive grounds decision in EAV and in the way the asylum claim was articulated in GMP, the recruitment took place in the Philippines, and indeed the transfer in terms of organising the visa, shepherding through the.
They paid for all of that, and they were the ones who perpetrated the deception by getting them to sign up to documents which said that their employer was X, and then they turn up and their employer is Y.
That's correct.
Yeah.
Okay. So it's the action is recruitment and transportation.
Yes, and then by means of, and this is the point, a really important point to emphasise. This is by means of the second line: fraud, deception, of the abuse of power or position of vulnerability of the victim. So that's what was the context here. It's not just the deception, but going back to my Lord Jeremy Baker's point earlier about is it just the deception? It isn't just the deception. It is the abuse of power or position of vulnerability, which is the means, and then we get to the purpose, which is exploitation, and hopefully we don't need to go through that, but importantly, exploitation, slavery, or practices similar to slavery. So that's what forced labour, or
It's servitude, actually, isn't it?
Or servitude.
It's servitude, and there is a difference in equally nasty, but this was a case of servitude, not slavery.
I think I can probably agree with that, but I'll just make sure that Miss Liu doesn't tell me that there's a distinction that I haven't myself appreciated. So,
Drawing it together, it's the action of recruitment and transportation by means of deception and or the abuse of a position of vulnerability.
yes,
And or is my insertion.
yes, I think that's fair.
For the purpose of exploitation by way of servitude.
That's correct.
Okay.
And so, and if I could just take the court down to yes, it particularly important, paragraph 77, that trafficking means much more than the organised movement of persons for profit. The critical additional factors that distinguish, particularly here, distinguish trafficking from migrant smuggling are for the use of one of the means listed: force, deception, abuse of a situation of vulnerability, and so on, throughout or at some stage in the process, and the use of that means for the purpose of exploitation. And then we get to paragraph 78, and the actions of the convention is concerned with recruitment, transportation, transfer, and we've
Yes.
seen, and the definition endeavours to encompass the whole sequence of actions that leads to the exploitation of the victim, and that importantly the reference to recruitment covers recruitment by whatever means, paragraph 79, and transportation, as it says, may be cross-border, it may not be in the circumstances. So as we set out in our, just for your reference, you don't have to go there, in our skeleton argument at paragraph 27, that the reference here at paragraph 82 in this document is that,
Well, is it 82 or 83 or both?
well, I've got both actually, which is that 82, fraud and deception are frequent use by traffickers, where victims are led to believe that an attractive job awaits them rather than intended exploitation. And 83, by abuse of a position of vulnerability, that's meant an abuse of any situation for which the person has no real or acceptable alternative to submitting to the abuse.
Could we just read? Would you allow
Oh, yes, sorry,
us
yes,
to-
please.
me to read?
Yes.
Okay, now I've got the focus of your
Yes.
a focus of your case, 83 and 84.
Yes,
I
thank
think you're going to say that we should also take into account 84.
Yes, indeed. And that's we've put that in our skeleton at
You
paragraph
have.
24.
Will you just let us read that? Thank you. Thank you.
Thank you, Mary. And so that was and the importance about that, obviously the vulnerability may be personal, situational, circumstantial, it may be in relation to social status, and that's why the victim of trafficking or former victim of trafficking as a PSG encompasses, we say, those characteristics. And it may be that it's a shorthand, and that may be why it wasn't particularly disputed before the tribunals. And just because it's just seeing if there's anything else in my note there. Just because my Lady Justice Andrews raised that question, the question of servitude, which is not of any lesser form.
No, it's paragraph 95.
It's paragraph 95, which is it's a particular form of slavery in these circumstances. So we have that. So coming back to where I was, which is that, and it's also set out in our skeleton at paragraph 28, just for the court's note, that what's important is that any consent is irrelevant.
Okay.
And that inherent in servitude, obviously, is the requirement to live on another person's property and work and perform services for them, and being unable to alter one's condition or situation. It is a particularly serious form of denial of freedom, even if it may not be a different type of slavery.
Yeah, well, there's a very useful explanation of Article 4B in paragraph 97, isn't there?
Yes, and that's...
I think it's quite clear that the reason why consent is irrelevant is because whilst it said somebody may wish employment and possibly even be willing to engage in prostitution, that does not mean that they consent to be subjected to abuse.
Indeed. So that is...
So consent to doing the job doesn't mean you consent to being treated appallingly while you're doing it.
Indeed, and that's, as we've set out in our skeleton, that is an important context for how these cases are articulated, and that and I think 90. Oh yes, we've gone to 97, which is, I think we don't need to go there further. Just to emphasise that, as we pointed out in our skeleton, that the where the consent is irrelevant where there's a recognised means of coercion or compulsion, including abuse of a position of vulnerability, which is being used for the purpose of exploitation, and that's actually also repeated in the Modern Slavery Act. We didn't put it in the bundle because it's not controversial, but that's where. So the question of consent, however, isn't simple, because coming back to the core issue of this question is, where does free will end and the constraints begin? Back to the question of,
Well, this arises in all sorts of areas of the law,
and this is
including
why
areas I'm more familiar with, of course.
if
I mean, free will is affected. The free will of a person in the position of vulnerability is a difficult thing to identify.
so in the context of these cases, we're concerned with whether the tribunals, upper tribunal in EAV or first tier tribunal in GMP, for EAV, were entitled to say, if she chooses to seek work abroad, she's taken herself out of the definition of protection against persecution in the Refugee Convention. And in GMP, I'll have to develop this with the case law, but I'll be coming there very shortly. Yes. In GMP, that the tribunal's entitled to say, well, she wouldn't seek to endanger herself. And that is effectively, we say, suggesting that there is an element of consent by a different form in reaching that conclusion. So again, we've set out those. I don't need to go through those again now. The definitions are in our skeletons, skeleton 24 to 26, and if each of the three components is met, then trafficking has occurred. And the focus of the definition is on the act and intention of the perpetrator. Obviously, that's the purpose again. So that's why we say that, of course, the consent of the victim is irrelevant. So the relationship, just coming now to the relationship between trafficking and the Refugee Convention, we set that out at paragraph 32 of our skeleton, which is that nothing in the Trafficking Convention affects the rights and obligations of states under the Refugee Convention. We don't need to go there. That's just in our skeleton at paragraph 32. And that's also in this ECAP report, paragraph 377, actually. Sorry, 373. But in order to then look at how these cases interact with the Refugee Convention, could we just look at the UNHCR trafficking guidelines, which are the tab 6, page 60. They start at page 60 in the bundle, in the authorities bundle. So starting at paragraph 10, that's the sidelined, which is, again, perhaps I can take this more quickly now. An important aspect of the definition is an understanding of the trafficking as a process, not a single act. Paragraph 13, which is that sets out various examples where a person may. So paragraph 13 is at page 65.
Yes.
The claim for international protection presented by a victim or potential victim can arise in a number of distinct circumstances. They may have been trafficked abroad, may have escaped their traffickers and seek the protection of the state they're in now, which is where the scenario we are hit here. But obviously we're concerned with the chain. And when it comes to a well-founded fear of persecution, so what the trafficking guidelines say, well, what will amount to a well-founded fear will depend on the circumstances of each case, unsurprisingly. A serious violation of human rights in paragraph 14, and we'll look at, if this goes down to paragraph 21. This is, well, paragraph 19, forcible deceptive recruitment of women and children for the purposes of forced prostitution or sexual exploitation is a form of gender-related violence, and then it's also goes on to trafficked women can be particularly susceptible to reprisals. That's not the case here. We're not talking about reprisals. And in certain settings, unaccompanied children, for example, may be particularly vulnerable to trafficking. And we're talking here about vulnerable women being susceptible to trafficking. That's how we put our case, and so that is really part of the way in which we develop the question of risk of persecution, because we're saying these are the factors that led to the appellants being trafficked in the past, and these are the factors which remain. There's no change of circumstances, and that therefore that's why we say they remain at risk of persecution in the future. And we also say that there's obviously we have to show there's no sufficiency of protection from these agents of persecution who are the traffickers, and we say that that in order to analyse that, we need to look at the Secretary of State's objective evidence and the trafficking in persons report that was before the tribunals. But we don't have to go there in this case, because those factors, as I said from the outset, were accepted. So we don't have to look at the question of sufficiency and what that evidence is, and I can respond to those points if we need to, if we get to that point in response to Lord Murray and his skeleton argument. But the tribunals proceeded on the basis that there was a real risk of re-trafficking from which the state could not protect, and there would be a risk of serious harm arising. And the only question that the tribunals were concerned with effectively was whether the appellant would or would not exercise that choice, a so-called choice, but we say would or would not be in that situation. And just the final point, so coming to the causal link, my lady asked me that question. Just for your note, we don't need to look at this, but for the note, the place of persecution is 25 and 26 of UNHCR guidelines. The causal link question, which is at, in these guidelines, starts at 29. And this is important, which is, we say, paragraph 31, trafficking in persons is a commercial enterprise. The primary motive may be for profit rather than persecution on a convention ground, but victims are likely to be targeted above all because of their perceived or potential commercial value to the traffickers. But the overriding economic motive does not exclude the possibility of convention grounds in targeting and selection of victims of trafficking. That's what we say when we talked about the question of selection. The selection of victims is that we say women in the Philippines who are from poor economic circumstances.
But not necessarily who've been trafficked.
That's what. Coming back to the question of the trafficking definition, if you have been trafficked, then it demonstrates that you've been someone who has the characteristics of being in a position of abusive vulnerability. Or,
yes.
Or susceptible to.
Going back to the means element.
Yes.
It does seem to me, as you're developing this, it's not so much on a further deception, but rather on use of a position of vulnerability. Is that right?
Yes, that is what, if you're a former victim of trafficking, that is what, so you already have got past persecution on the basis of the abuse of your vulnerable position.
Yes.
When you go into the recruitment agency, you're not going to turn up and say, I'd like a job, and by the way, I was a past victim of trafficking.
My lady, I totally accept that, but going back to, we'll come to the objective material hopefully quite briefly when we look at the trafficking in persons report, but the traffickers do not treat all people the same. So they will look at the people who come into their, or the appellants as they come into their recruitment agency, and they'll look at what their characteristics are, their age, their economic circumstances, why they're looking for employment, and will form their own view about whether they have vulnerabilities which are capable of being abused. The evidence in these cases is that they have already been able to demonstrate that.
Well, that's, you'll have to take us that evidence when you get there, because that, for my part, that seems to me to be quite an important part of
my
your
lord, the
case.
short answer to that, when I said is that the fact of it having happened to them already. We obviously can't define the particular social group by reference to persecution, but we can define it by reference to characteristics. And we say that these are self-evident because the appellants were not trafficked because they were robust young women looking for a better life in the Middle East. They were trafficked because they went into a job saying, I'm looking for an recruitment agency, saying, I'm looking for employment. I need to earn a certain amount of money because I've got families to support. I'm the head of household because my other husband isn't supporting, or I don't have a husband. And I'm under economic pressure. I'm living, and
I mean, there is a difference. There is a difference, isn't there, between the initial act of trafficking and the postulated further act of trafficking. The initial act of trafficking, the act's the same, the purpose is the same, but the means is different. The means is or are deception plus abuse of, or taking advantage or abuse of, the vulnerability of a economically poor woman. Deception is plus, and that would seem to fit what happens in most cases. But in a re-trafficking case, it must be different, mustn't it? In the deception, there isn't the deception. It's abuse of a different form of, on your case, vulnerability, namely the fact that they are already a victim of trafficking.
My lord, I think I would. When I call it re-trafficking, I think I hesitate to call it re-trafficking. It's a risk, a real risk of being trafficked again. And the reason I haven't used re-trafficking, because it's not specific to a particular trafficker.
Future trafficking.
Yeah, I'm sorry. I mean, that was a shorthand on my part.
But my lord, it's right to say that there still can be deception, because even though the individual appellant knows that some recruitment agencies are deceitful, some are not, and some of them do offer proper employment. The appellant, the abuser, the trafficker, the recruitment agency won't necessarily offer the abusive position to any woman who walks in. Coming back to but the question is whether they will identify the appellant as somebody who has those characteristics, and then abuse, i.e., the characteristics of vulnerability, which when we're analysing them now, we know they exist because it happened before, and then target them in that way on the basis of that vulnerability. That's how we characterise it. So if a sort of healthy young man walked into the agency, he wouldn't necessarily be subject to the same risk of abuse because he's not necessarily vulnerable. He's not someone whose vulnerability can be exploited or abused.
Even if he'd been trafficked before.
Which is why the former victim of trafficking we've called, I've recategorised that to say former women victims of trafficking from the Philippines, because that's actually who we're dealing with, and that's actually the circumstance we're in here. So that's where I'll just turn my back for a moment in case there's some. Yes, I mean it's right to say that the deception, just because one has been deceived in the past, doesn't mean that there will be that that the next going to be deception. And also, it's not immediately obvious. Somebody hands you a contract, you think, great, this is an actual contract of employment. I can sign that. It says I'll be doing 35 hours a week and I'll have these holidays.
Okay. Well, I withdraw my oversimplistic point.
Great, my lord. And the individual can't know what the motivation of the trafficker is, or whether indeed they are a trafficker. This is the question of establishing risk based on past history and past characteristics.
Okay.
And so, just just whilst we still have open the, I have open anyway, the UNHCR guidelines on trafficking, that at paragraph 32, then it talks about members of a certain race or ethnic group may be especially vulnerable to trafficking. But, and then about 6 lines from the bottom, as an example, among women or children in a particular society, or some subset of women or children may be especially vulnerable to being trafficked and may constitute a particular social group within the terms of the refugee definition. So this is starting to assist, I hope, the court with trying to grapple with this, which is a rather difficult question in one sense. But the UNHCR recognise that it may not be all women, but it may be a subset of women who are particularly vulnerable. Why are you vulnerable to being trafficked? You're vulnerable to being trafficked. Part of the definition of trafficking is abuse of your position of vulnerability, which is why being a former victim of trafficking is important to identifying the group. Even if an individual isn't trafficked solely, it says, on or exclusively for a conventional reason, one or more of the convention grounds may be relevant to the trafficker's selection of the victim. And it's that we say is important here, because the traffickers are the ones who are selecting the victim, focusing on the motivation of the traffickers, because it shows that they're selecting and targeting certain groups rather than, as characterised by the upper tribunal and the Secretary of State, as a voluntary act of an individual undertaking an act to seek employment. So, yes, two people with the same characteristics would not necessarily be, with two people with different characteristics wouldn't necessarily be targeted. And what we have here, hence my uneducated young woman or sort of other healthy young man, and in this context, what the appellants have by their shared past experience is what they fear on return. I think I've just, the points that come from that are, this isn't a recipe for floodgates. In order to make good your refugee claim, you have to have some way to evidence your persecution or risk of persecution, i.e. what makes you vulnerable to the abuse. You need to be outside your country of origin by reason of that fear. We have here an accepted history of persecution, so that's a narrow cohort, and you have to factor that into to assessing the refugee claim. So somebody who's a potential victim of trafficking would find that rather more difficult to make good, because they'd have to show that what their personal circumstances were, that they'd looked for employment, and that there was still a real risk of trafficking, that the state couldn't protect them. All of that without any evidence of which had happened, which is not where we are here. And finally, the question of harm is at 37 of these of the guidelines, page 72, which is whether the risk of persecution or harm is not only in the past but in the future is because of that membership, and that's the very bottom of 37. Whilst the claimant must still demonstrate a well-founded fear of being persecuted based on his or her membership of the PSG, they need not demonstrate that all members of the group are at risk in order to establish the existence of the group. That's and at 38, women are an example of a social subset of individuals defined by innate or immutable characteristics and are frequently treated differently to men. As such, they may constitute a particular social group, and then factors which may distinguish women as targets for traffickers are generally connected to their vulnerability in certain social settings, back to why we've defined them as former victims of trafficking, because they can show that vulnerability through that history. And so, back to the Secretary of State's contention and the upper tribunal's contention, that is, if you're a former victim of trafficking, you'll be live to the question of deception, and therefore you are less likely to be persecuted. That is, we say, a perverse when you examine that against the protective principles of under the Refugee Convention. And we need, in order to examine that they have been accepted. I just want to give for the court to note the references to they have been trafficked in the past, because I think those are important parts of the factual and evidential picture. and then I'll come on to take the court through those authorities which
Yes.
I've been promising, but haven't got to so far. So the first common ground in relation to EAV is that she had been trafficked in the past, is her conclusive grounds decision, which was on the 14th of July 2022, supplementary bundle 222. I'm not going to take the court there unless we want to go there. I can just summarise what was said, and for the place of exploitation was the Philippines. That was accepted. Agency staff accompanied her onto the plane to Saudi Arabia and through immigration. That's page 227.
Do we need to worry? Excuse me, members. Do we need to worry about this?
No, it's
I mean,
accepted.
It's all
I
accepted.
just, this is all, it's not in dispute that both these appellants were victims. Unless there's any particular factor in the way it's been described that you want to draw to our attention.
I just wanted to emphasise that in both cases, there was no dispute that the recruitment and the action started in the Philippines. Because,
Absolutely.
and that's important because the upper tribunal got that wrong in EAV.
Well,
they
you'll
got
show us that in a minute, but
Yes,
we can take this shortly, can't we?
yes, okay.
It's conceded that both these appellants were victims of trafficking, and came within the convention at the time when they first arrived. Is
In
that right?
fairness to the upper tribunal, they were probably led astray because previous counsel actually said that the exploitation took place outside of the Philippines and was not taking into account the overall picture. So I think we have to forgive them for perhaps being led astray on that point. But it doesn't matter because there, as my lord says, there is an acceptance that they were both trafficked.
Yes, but
it started in the Philippines.
Yes, but the upper tribunal. I understand that. I think why the upper tribunal went wrong, and they may have gone wrong because of the way in which the minute of the conclusive grounds decision was reached, or whatever. But they failed to engage with the critical question in order to identify future risk. Is that not that she would be targeted in the Philippines, that she would be in the Philippines and would be within a group who were targeted. That is the core point that the upper tribunal.
We're going to come on to that
definitely
when we
got
look at
wrong.
the decision. But
Yes.
you want to take us to the authorities now? please?
Yes. Let me just move on to. So we start by. Sorry, just looking back through my notes. We address. Just go down. Right. Yes. Let's look at fauna.
Tab
So
15.
that's tab. Get to mine.
Tab 15, 284.
Yes. So, fauna was which 284 of the authorities, it itself addressed Shah and Islam, both of which were considered an HJ. So hopefully I don't have to deal with Shah itself. We can just look at fauna for the moment. As you can see from the head note, the two appellants were appealing against decisions that they weren't refugees within the definition of Article 1A2. Kay had been subject to ill treatment in Iran by the Revolutionary Guards on the basis of her relationship with her husband, i.e. as his family member, which had been, the Court of Appeal had said wasn't a particular social group. And perhaps more importantly for our purposes, in F, she had fled Sierra Leone, having to avoid undergoing FGM, which was formed on the majority of women, girls in Sierra Leone. So, importantly, in this context, the UNHCR guidelines, which were on a particular social group, were approved. We've got those in the bundle. I don't necessarily need to take you there for these purposes. Let me just go to my notes. So look, it might be useful to start with Lord Bingham at paragraph 10, page 301. So paragraph 10 gives you the Refugee Convention definition. Just again reminding ourselves, well established, it must be in accordance with a broad humanitarian objective and having regard to the principles expressed in the preamble that human beings should enjoy fundamental rights and freedoms without discrimination, and that refugees should enjoy the widest possible exercise of their rights and freedoms. And then Lord Bingham then addresses paragraph 11 and 12, the social group. By contrast, the end of paragraph 11, the meaning of a particular social group, for all the apparent simplicity and intelligibility of that expression, has been the subject of much consideration and analysis. So we can see that it's not, that there has been some difficulty. The leading authority is Shah and Islam. Yeah. And as you can see, perhaps you could just read that paragraph.
Read 12.
12. And I'll just emphasise that what he concludes is that even within the courts themselves, their lordships themselves, they couldn't agree.
Okay, well, let's read it and
Yes,
see
thank you.
where we get to. Right, we've read 12.
And then could you look also, so if I could invite the court also to look at 13, the points of principle.
Right, we've read 13.
So as you can see, important and what 14 says, when the concept of particular social group was first developed, it was more concerned with identity of conscience and so on, which I think goes back to my Lord Justice Jeremy Baker's point. If we move on to paragraph 16, you then come to 15, actually it's page 303. Increased reliance on membership of a PSG as grounds for claiming asylum prompted the UNHCR to have issue their own guidelines. And you can see there in the guidelines at paragraph 12, the definition includes characteristics which are historical and therefore cannot be changed, and those which, though it is possible to change them, ought not to be required to be changed because they're so closely linked to identity. And it follows that sex can be properly within the ambit of social group category, with women being the clearest example of the social subset defined by innate and immutable characteristics who are frequently treated differently to men. And that it's also correct. You can't define, I can't find that quote for a moment, but you can't define the group by reference to the persecutory act, but it can be a relevant factor in determining vulnerability. So we are concerned with that scenario here. That's just before paragraph 16 on page 304.
Are you happy with the UNHCR definition as being the appropriate definition that we should apply?
I mean, the UNHCR, these are guidelines. So what they're saying is some immutable characteristics such as women, for example.
There's a definition. It's described by Lord Bingham as a definition anyway. Paragraph 15. A single standard, both dominant approaches. A particular social group is a group of persons who share a common characteristic other than the risk of persecution, or who are perceived as a group by society. Characteristic is one which is innate, unchangeable, or otherwise fundamental to identity or conscience, etc. So sexual orientation. And then in paragraph 13, the guidance says if it's based on a characteristic that's neither unalterable nor fundamental, then you need to carry out further analysis.
So
decide whether society perceives them as a
Yes.
recognisable group.
in this case, Lord Bingham and Baroness Hale adopted a broad definition of the particular social group, which was that women in Sierra Leone were at risk of FGM.
Yeah.
That's not because all women could show they would be persecuted, but they would be susceptible. Lord Hope described it as, which is yet so a reference to Lord Hope is at paragraph 56, page 321, which was uninitiated women, i.e. women who haven't been subject to this, and he and Lord Roger was in favour of a narrower construction, and he referred back to Lord Hoffman as saying women in Pakistan is too broad,
Right.
women in Sierra Leone is too
Well, you're going to take us to these passages because what do you say the ratio is that we
So
should follow?
In fact, the court agreed that there was a particular social group and defined it in different ways. So that brings me back to the question here, which is that as long as we fall within a particular social group that we can identify, which is either women in the Philippines or women who are in poor economic circumstances, bearing in mind that this wasn't an issue before the tribunals and everybody accepted former victim of trafficking was the social group for the material purpose, and that hasn't been part of a pleaded case by the Secretary of State or a cross appeal or anything like that. This court should proceed on the basis that former women victims of trafficking in the Philippines are a subset of women in the Philippines who were from
Right.
poor economic circumstances.
If we just try to looking at what we get from fauna,
Yeah.
we have the definitions recited by Lord Bingham, UNHCR definition recited by Lord Bingham in paragraph 15. The key part of it is, as I think Milady said, paragraph 30 of that definition. That's where we look at what is meant by a particular social group.
Yeah.
And I think it's possibly the last few words of that definition that matter, isn't it? They may constitute a particular social group if in the society they are recognised as a group which sets them apart.
Yeah.
Is that would seem to me, off the top of my head this night, to be the key part from the guidance.
Yes.
Now, my question to you is, bearing in mind this is as you said, this is a case where the House of Lords Supreme Court has rules the roost in terms of construction. Is anything said about that phrase in the speeches, if they were still speeches?
Well,
then, of
yes.
the
If I would say I will take you to the way in which it has been developed because of the way in which the different their lordships approached it differently. So that's one analysis, which is the broadest analysis. Women within the country concerned, which was the one Lord Bingham accepted, and so did Baroness Hale.
Just so I know what I'm looking for.
Yes.
Well, then, insofar as they make any comment on that phrase at the end of paragraph 13, it's to be detected in their application to the facts of this case.
Of the case before them, which was
Yes.
about women who were at risk of FGM. So if I can just take my lord down to paragraph. It's page 312. Think of.
Yeah.
314, apologies, paragraph 31, yeah.
Right.
Just to explain the point, which is that perhaps I'll just take you back one stage to paragraph 29 to explain what the Court of Appeal did and why the House of Lords differed. In the Court of Appeal, Lord Justice Chadwick concluded that the particular social group could not be defined as all women in Sierra Leone or all young single Sierra Leonean women, because defining the characteristic of the group was inseparable from the persecution which the person feared. Lady Justice Arden, paragraph 30, thought that women in Sierra Leone and women in general couldn't be a particular social group so defined because it include women who no longer feared FGM because they'd undergone it and might practice on others. Paragraph 31, departing from the submission below, but with the support of UNHCR, Miss Webber for the second time submitted that women in Sierra Leone was a particular social group, and
But the reason is because they're perceived by society as inferior.
yes, and that was sharing a fund with, yes, that was the analysis.
First 10 lines or so of 31.
Yes, and at the very bottom of 313, this was Lord Bingham's conclusion. I have no difficulty in recognising women in Sierra Leone as a particular social group, and I would. He said, if, however, the wider social group was thought to fall outside the established jurisprudence, a view I do not share, I would accept the alternative and less favoured definition advanced, which was intact women in Sierra Leone. That was the solution. And Lord Hope, if I can just take you to paragraph 56 at page 321. Well, yes, he says that part 56, it's possible to define the particular social group more precisely. That's more precisely than the Lord Steyn observation in Shah, which was in the previous.
Do forgive me, which paragraph are you
Sorry,
reading?
56 at page 321.
Thank you.
Could I just go back to 55 to contextualise the observation made by Lord Hope? The question is whether women in Sierra Leone generally cannot constitute particular groups because they've undergone the process, they're no longer at risk of being persecuted in that way. That reference back to Lord Justice Old in the Court of Appeal, which is, it is wrong to say, it's about 6 lines down, that a particular social group cannot exist because not all of its members are at risk. As Lord Steyn observed in Shah, some homosexuals may be able to escape persecution because of their relatively privileged circumstances. Back to, I think, my Lord's point about some people having not being in those in that group. Even the most targeted of groups may contain some powerful or well-connected individuals who are able to escape persecution. That's visited on everyone else. Some women in Pakistan are able to obtain protection because of their particular circumstances. Yet these objections were not held to be a satisfactory answer to the argument that women in Pakistan were generally a particular social group. So Lord Hope, it's possible to define it more precisely. And then 5 lines down, one can say with a greater precision that the particular social group is composed of uninitiated indigenous females.
Forgive me, is that the same as intact?
Intact, I think that's right, yes, I think that's correct. And I don't think there can be any objection to defining the group in these terms. It has the advantage of excluding those who've already been initiated, because they can never be in any circumstance said to be at risk. And then at the bottom of 56, there's no need to add to the definition of the particular social group elements which explain why particular members of the group and not others are singled out for persecution. Those elements have to look at under the head of causation anyway. And then if I could just wanted to take the court to Lord Roger at paragraph 70.
Just pass over paragraph 58 of Lord
Oh,
Hope.
so sorry, let me go back to that.
I'm just reading the last few.
Because paragraph 58 of Lord Hope is quite important.
Yes, I agree with you, but I'd avoid attempting to define the class as to confine it to the people who are likely to be persecuted. It's enough that they should identify the shared characteristic, the common denominator within the wider group that reflects the reason why membership of it gives rise to a well-founded fear. And that's
very much his final position in relation to definition of a social group, isn't it?
That's right.
So he says if there's you find out what the common denominator is. In our case, ex-trafficking, somebody who's been trafficked.
Yes.
And you say, is that the reason for the persecution?
And we say, back to the point I've made earlier, which is that because the way in which the trafficking occurs in these cases is about abuse of position of vulnerability, that is for these. It doesn't mean to say that somebody might launch an argument about other potential victims of trafficking, but we're not arguing that here because we don't have to. and because the narrower focus is totally satisfactory for our purposes, which is that as a former victim of trafficking,
They're
we have
vulnerable.
a
Yes.
woman victim of trafficking.
You say they're targeted because they're vulnerable, and you can show their vulnerability because they are former victims of trafficking.
Yes.
Yes, that's.
Can I just go back? Forgive me for being so slow, Miss Lee.
No,
Can I just go back to the last of 56, just so this may or may not be relevant. Here, Lord Hope says, there's no need to, and you've read this quickly, but this is why I'm going back. There is no need to add to the definition of the particular social group elements which explain why members of the group and not others are singled out for persecution. Those will have to be looked at anyway under the head of causation.
yes.
So is that the answer to my point, that there's no need to define, to narrow the social group of women who were previously trafficked to exclude women who were previously trafficked but are now married to a rich man or whatever.
Yes, that's
Because that's a question of
so
causation.
we have to show about do you have a well-founded fear, but are you outside your country of origin because of a well-founded
reason of.
fear? By reason
By
of.
reason.
It's back to where he's not. Right, thank you. You wanted to take us to Lord Roger.
Yes, if I may, Lord Roger, just because each of the law lords gives their own analysis, and then
In the way that happened in those days.
in the way that happened. Yes, that's right. And paragraph 70.
Yeah.
Except the real risk of persecution was on account of the PSG. It's a very narrow issue. He wanted to make it a narrow analysis. So it's important to emphasise, in line with international opinion, Secretary of State accepts practice of FGM as abhorrent. It's also inhuman degrading treatment. The question which divides the parties is simply, perhaps it's an overemphasis, whether the appellant faces enforced serious harm involved in mutilation for reasons of the PSG in terms of the Refugee Convention. If so, that the Home Secretary accepts that you have a fear of persecution. The point is very narrow, and at paragraph 73 to 75, he says, convenient summary of the case law is paragraph 73, immutable characteristics. Secondly, the characteristic attribute common to all members of the group cannot be the shed fear of persecution. And thirdly, possession of the characteristic attribute must distinguish the group from society at large. Paragraph 74, being a woman is a sine qua non of being a victim. In other words, but for being a woman, persons couldn't be selected as victims of the practice. But it may be as oversimplification, as Lord Hoffman identified in Shah. Then he goes to look at uninitiated women. 75, he says, to put the point another way, if one were to stop the person who was about to perform the mutilation on an unwilling victim and ask why she was doing it, she wouldn't say she was a victim of the woman, but because she was an intact or uninitiated woman. And so, in terms of the convention, it would not be for reasons of her membership of a social group of women and girls, but her membership of a social group of women and girls who were uninitiated and uninitiated and intact. To put the matter in yet another way, while it is not necessary that all members of the social group in question are persecuted before one can say that people are persecuted by reason of their membership of the group, it is necessary that all members of the group should be susceptible to the persecution in question. And that was the point I just flagged at an earlier stage of my submission, which is to narrow the definition. Don't define it by the persecution. And that's what he was saying, which is that not everybody who in the group has to have been persecuted, but they have to be susceptible to it by virtue of their membership of the group. And then finally, he says at 80, if I'm wrong, it's women who face enforced FGM. That's what he says at paragraph 80.
Of course, in that case, the evidence was very clear that intact women face discrimination and being shunned in society, and therefore they were recognised as a separate group.
Yes. So,
Is it helpful just to apply these facts of our case to what Lord Rogers said? I mean, we knew you were going to come on to Lady Hale.
So yes, and so what he's really saying there, applying that here, is that we're not necessarily saying all women in the Philippines maybe not even saying all women in poor economic circumstances. We're saying that women in the Philippines who are former victims of trafficking have the characteristic of being able to demonstrate that they are vulnerable to abuse of their position.
So are women who haven't been trafficked.
That may also be the case, but we don't have to make that argument for these appeals.
Well, I know you don't have to make good that argument. You've got to try and get round it, Miss Nate, because otherwise you don't have the causal connection between the group and the targeting.
Well, we are, even if the group were broader, but we say that we can say the narrower group of women, former victims of trafficking, women victims of trafficking in the Philippines, have those characteristics because they share vulnerability, and that if they were to be returned to the Philippines, that when in the process of seeking further employment, and that's the causal question, which is actually what the real focus of these appeals is, they would, by virtue of those characteristics of being vulnerable and having been trafficked in the past, which it's not the fact of the trafficking, it's the fact of the vulnerability. I think that is the better way to describe it. Would lead to the risk in the future. But if that is too narrow a definition, and this is what was concerned with concerning the courts in Shah and in Fauna, then the broader definition, even though it encompasses a potentially larger group of women in the Philippines who are in poor economic circumstances, would be sufficient for our purposes, because the causal question, why would they be at risk of persecution on account of being a member of that group, is then a question of evidence, as in why would you be at risk? It is a little bit of a...
So really, is the trafficking, the previous trafficking, got anything to do with that? I mean, why are you not just plumping for being female in poor economic circumstances in the Philippines?
Well, for the previous trafficking is on the facts of these cases, and again, this is why the tribunals never got into this argument, because it was all agreed. Because the previous trafficking is the way in which the claimant evidences their claim as to why they'd be at risk again in the future. But it may, so we have to, the first argument is the narrow definition, and the fallback argument is the broader definition.
Well, this case has been advanced on the narrow definition.
Yeah, it was advanced and accepted, so it wasn't in dispute. And I appreciate that my lady and my lords have asked me to address this, but I've been reminded, because none of the... I've been reminded by my solicitor, who did act below, whereas myself and Miss Lou did not, that this did not form any part of any...
Well, that's a fair point, but you understand why we're with a broader perspective
I totally
testing.
understand that. And it's,
But is it your case that in fact there may be two social groups here who would fit? One would be women of impoverished means generally, and another group which is women who were previously trafficked. And whether or not these appellants fell into the second category, the first category, is irrelevant for the purposes of this appeal. The fact is they fell into the second category. They fell into the category of previously trafficked women.
My lord, with that is how the tribunals approached the question, and the only question that the tribunals were concerned with was wasn't the causal link. They were concerned with whether on the facts, the core question was, would they actually seek employment because of their factual history? I think that's why my learned friends at Skeleton Argument and ours are quite different, because we're trying to go through the principal questions, but actually that's the core question. Was the tribunal entitled to reach the conclusion it gave, which was overturning the first tier in EAV and concluding, no, this is just a question of choice and free will, and GMP for similar reasons that turned on its head. Sorry, my lady, I think has a question.
No.
Ah. Hope
Okay,
it wasn't a
all
frustration.
right. Did you want to take us to Lady
Yes,
Hale?
And so I'll take you to Hale, which is paragraph 98, page 334. Let's see.
Para 98.
Oh yes, just sorry, I've got the wrong.
95 is flat, is
Yes.
sidelined. Semi-clean.
Let me just go down. I'm sorry.
Well, she begins.
sorry,
PSG begins at 97. doesn't it?
Yeah, she starts her assessment there at 95. 97 particular social group. The particular reference she makes at 98 actually was with reference to the UNHCR guidelines. I just wanted to emphasize this point, which is the guidelines that were approved by the court in this judgment, which is the second half of that bit, which is that to preserve the structure and integrity of the Convention's definition of a refugee, the social group cannot be defined exclusively by the fact that it is targeted for persecution, although, as discussed below, persecution may be a relevant element in determining visibility of a particular social group. So, whereas previously we were just looking, it can't be defined by targeting by the persecution, and now that's just ruled out on the basis of exclusivity, and that's what she then goes on to say at 109, I think it is, which is the sideline part, which is. So she's accepted the broader definition of women in Sierra Leone, but the purpose of taking to this part of the judgment is to make good that even if you have a broad group, it doesn't mean that this is the proper construction of the Refugee Convention. It can't make any difference that the practice is widespread, and it references back to harmful practices in breach of international law can't be justified in any way. So the fact that even if there's a large group of people in Fauna, a large group of women in Shah who were liable to fall within the group, but and it was back to the argument about floodgates, is that it doesn't seem to, that hasn't impacted upon the court's analysis of what is or is not a particular social group. And just for completeness, at 1112, that the stumbling block seemed to have been the fact that FGM was a once and for all event. Once done, it can't be undone or repeated. Thus, it was argued if members of the group are no longer at risk because they've suffered it, they can't constitute a risk for this purpose. But if one looks at if the group has to be defined only to include those at risk, then it looks as if the group defines solely by the risk of persecution and nothing more. That's why she's gone for the broader definition.
114 is her final, where she ends
Yes,
up.
and
isn't it?
then-
And that's sort of where Lord Roger was.
Yes, for the PSG might be best defined as women belonging to those ethnic groups where FGM is practiced.
Yes.
It's quite clear that that's the reason for the persecution. It matters not whether the group is stated more
I
widely
think that is most.
or more narrowly. So Lord Roger, I think he ended up with women who faced enforced FGM. So we're back to where we are, which is women who are women. We can't say women who are at risk of being trafficked because that would define them by the persecution. So you define them by their characteristics, which are women who are of low economic circumstances, but as the broader group. But the narrower group, which was the one that we were from, which is former victims of trafficking, partly because the Secretary of State accepted that in the decision letter and never challenged it and never used that as an argument not to justify the risk of persecution, and partly because it catches the characteristics as to why those women are susceptible to trafficking in the future. I don't think I can make it better than that.
Okay.
Thank you.
We take a long time on fauna. Where do we go to
So
next?
from there,
HJ Ram.
I just wanted to go to the case of Ahmed just first, and then I'll go to HJ. The purpose, because I think my lady if I'm right in remembering who asked the question, says why does it matter that somebody's been trafficked in the past? How is that relevant to the future risk of persecution? So if I can before we just go to the it's in the immigration rules for a start, which is at 339K. That's page 57. The fact that sorry, I'll just wait.
Sorry, what are we going to?
So it's it's in the authorities bundle at page 57, which is tab 5 for those on paper copy. It's the immigration rule. Past persecution is a serious indicator of a person's well-founded fear of persecution.
Forgive me, are you reading 339K?
Yes.
Thank you.
Yes. Unless there are good reasons to consider it wouldn't be repeated in the future. So we say, in short, that there's no change of circumstances, and more importantly, in both the appellant, you've got the unchallenged trafficking evidence and the unchallenged objective situation as to the drivers of persecution.
That's a general proposition that's there for guidance. But I mean, you can't simply say, I've been persecuted in the past, therefore I fear I'm going to be persecuted in the future. That's a non sequitur. There may be certain circumstances in which that is a perfectly legitimate inference to draw. And we see that there are cases, for example, where people are returned to their home countries and they're targeted by the traffickers because they know the village from which they come and they're going to get them back. You can't put it in the context of the actual facts of the case. No, you can't just extrapolate the rules out, the immigration rules, and say,
my lady, the purpose of putting that, and then with the reference, I don't need you to turn it up because it says, I'll just give you the case of Demikaya, which is in tab 12, page 230. We don't need to turn it up. It's a simple, the court was just looking at the question of a matter of common sense in the absence of a change of circumstances. And that's the point I would seek to get from that, which is there's no change of circumstances. There's no change in the objective material in relation to the CPIN, the Secretary of State's country information, nor the trafficking in persons report. No material change, and also the trafficking report, expert reports, they weren't challenged. The expertise wasn't challenged. The contents weren't challenged. So none of that was in dispute, and both tribunals upper tribunals in particular, go to pains to emphasise that is the situation.
That there was a greater risk.
That there had been no change in the objective situation in terms of who was likely to be trafficked, what the drivers of the trafficking were, what are the characteristics.
Okay,
The
right.
Secretary of State seeks to argue about sufficiency of protection, but both tribunals proceeded, as I've said, on the basis that that was not an issue, that it was a real risk based on the choice question. So that's where we get to the real core is, would she be at risk if she went abroad, and was she entitled to, what would the appellant do on return? And the legal question starts with Ahmed and then HJ and RT, which I hope to be able to get through quite quickly. So Ahmed
Tab
is
14.
tab 14. Let me just get to that's at 275. And you see there the head note about criminal justice Simon Brown's was at page 275 and 27. That's the head note 275, which was about whether it was reasonable to expect a person to refrain from their activities on return, in this case of proselytizing, to avoid a risk of persecution. And this
the answer is that's not the right question. Reasonableness doesn't come into it. They're entitled to proselytize if they want to, and if they want to proselytize, they shouldn't be persecuted.
In summary, it precisely that.
It's the forerunner, isn't it, of HJ Iran?
That's correct. And just again, the core point, we don't necessarily, apart from that proposition, I don't need to go too further from it, which is at 281. In all asylum cases, there is a single question to be asked. Is there a serious risk on return that the appellant will be persecuted for a convention reason, and if so, are they entitled to asylum? It matters not whether the risk arises from his own conduct in this country, however unreasonable. And that was then going on to persons who had a cynical or created an asylum claim on bad faith grounds. We're not concerned with that here. Of course, we're.
Do you draw from that? It matters not, just to extrapolate into this case, it matters not whether the risk arises from his decision to seek employment outside of the jurisdiction, however unreasonable that might seem in the circumstances, because that is irrelevant. That's the whole point, isn't it?
Our point is that it's legally irrelevant to
It's your
determine.
choice point.
Yeah.
Choosing is irrelevant.
Choosing is irrelevant. It's legally and factually irrelevant. The question of reasonableness doesn't come into it. So, on the facts of EAV, it was accepted fact that she would, and on the facts of GMP, it was part of the reasoning was she wouldn't endanger herself, which we say is impermissible when she said that she would do. And I'll come back to those how that applies on the facts just after lunch, if I may, because I just want to take you through HJ and RT, and I could stop there and then deal with the facts very quickly after.
Yes.
So HJ is tab 16, page 342, and this is obviously the longest case to analyse in the sense, although the court may be very familiar with it. So the head note at 342. It's considering Ahmed, but in this case context, in the context of persecution on grounds of sexual orientation, and about whether a person is entitled to the protection of the Refugee Convention if they could avoid persecution by modifying their behaviour. Lord Roger gave the main judgment, and let's just go to that, which is at 43. So let me just yes, he sets out we may well be familiar with the facts, but the facts are at 43. The tribunal said it's accepted for a person to be openly gay in Iran would attract a real risk of persecution. The issue is therefore about whether the need for him to be discreet about his sexuality on return to Iran and whether that would constitute persecution within the meaning of the Refugee Convention. And in particular, in that case, that the person had the tribunal had relied, letter H, I think it is, it's something he'd done so before. Just on the evidence, he was able to conduct his homosexual activities in Iran without serious detriment and without causing him to suppress many aspects of the sexual identity. That was on the facts of that case. And the finding of the tribunal was that if he were open about his sexuality, this is at paragraph 46, page 381, that he would be at risk of persecution, but would be unlikely to come to any harm if he were to conduct the relationship in private. And so, paragraph 52, but just might ask the court to read 52 to 53. This talks about the rationale of the Refugee Convention. Perhaps I'll just let the court read that.
Thank you. Do sit down if you wish to. you want us to read beyond 52,
Yes, well, I wonder,
53?
my lords, I was just also going to take you to 57, 58, 59 and 62. And then we come, and I'll take you to the, and 65, I'll take you to the conclusion. Which is,
57, 59, 62, 65.
yeah, and then take you to the conclusion at 66.
Yes. And you want to take us to 66, do you?
Thank you, my lord. That's where we say that 66, a tribunal would fall into error if it failed to ask why an applicant would act discreetly. And the question is particularly important in the context of the asylum claim for in a sexuality case. So the conclusion, if I can go to the passage just before paragraph 68, which is on 388, in short, the fact that the applicants would act discreetly and not be subjected to violence if returned there to Bangladesh, looking at that case, didn't mean that they didn't have a well-founded fear of persecution on their return. Rather, the tribunal had to go on to ask why they would act discreetly, and if it was because they'd suffer serious harm if they lived openly as a homosexual couple, then they'd have a well-founded fear of persecution, since it's the right to live openly without fear, which the convention exists to protect. And so, the conclusion. So the court then look at a variety of other of international cases, and the conclusion, which is that let me just get down to the
Key passage is 82.
82, which is my conclusion. So that's the summary from Lord Roger, which is: are you satisfied that the person who's live openly would be liable to persecution? Would they in fact live openly and be exposed to a risk of persecution, even if they could avoid the risk by living discreetly? If the tribunal concluded that the applicant would in fact live discreetly and avoid persecution, it had to go on to ask why they would do so. If it concluded they'd live discreetly because that's simply how they wish to live, or because of social pressure, such as to avoid embarrassment, then you avoid then the claim should be rejected. But if the tribunal concluded that the material reason, or a material reason, I should say, for the applicant living discreetly would be the fear of persecution, which would follow if you were to live openly as a gay man, then all other things being equal, the application should be accepted. That's a well-founded fear of persecution. And to reject the application on the ground that he could avoid persecution by living discreetly would be to defeat the very right the convention existed to protect, which is the right to live openly and freely as a gay man without persecution.
Does that passage apply by analogy to our case, and if so, how?
that is how, obviously we can't point to a case which will take us on all fours. We say that the appellants are, I should say, victims of trafficking, and that which is accepted to be constitute persecution through the elements that we have been through. We say that they face a real risk of being re-trafficked, and that was accepted if they were, that's the both tribunals proceeded on that basis, if they were to seek employment abroad. And the question, this isn't a question of identity in the same way as HJ was a question of identity, but it is a question of the principles, which are serious violation of human rights if the person seeks employment, which is a legitimate action. It is a consequence of a failure of state protection, which is why you're seeking surrogate rights under the Refugee Convention. It is a consequence, it does engage the non-discrimination principle and the principle of dignity, which the court in HJ were concerned with. If you go back to looking at, I think it's Lord Hope's judgment at the beginning, yes, 12 to 14, we don't have to go there. And the question, and it is therefore a question of what will the person actually do on return, and is it causative? So this is back to my Lady Justice Andrews' question, which is why would the appellants seek employment abroad? That we say it is not a choice. It is simply not saying I want to get a better job, I'm a football player and I want to go and play for some Middle Eastern team. It is not that. The reason the appellants are seeking employment abroad is because of their very particular economic circumstances.
Can I just ask on that? I mean, much of, sorry to interrupt, much of what you've taken out of HJ is based, as you mentioned, on the failure of the state to protection. In the case of HJ, it was a mutual characteristic of their sexuality, which the state auto protected didn't, etc., and therefore the persecution remains. But in this case, therefore, what's the failure of the state? The failure of the state must be, therefore, that they remain poor, that they remain in economically challenged circumstances. How is the state
in HJ, the characteristic, the particular social group was sexuality, and the failure of state protection was to
have laws around
protect them from harm arising by reason of being gay. Here,
if there had been such laws, then assuming that they were enforced to a reasonable degree, that claim probably would have failed.
If the court had found there was a sufficiency of protection, which is through
the only reason you're going to be able to protect them from themselves, as it were, is surely to level up to a reasonable standard of living.
No, because this case is concerned with, with respect to my lord, this case is concerned with women who are legitimately seeking employment because of their particular poor economic circumstances. Exactly. And I
without that you don't get anywhere, do you?
On the facts of the case, we say that they're entitled to seek employment legitimately, and also on the facts of this case, they have sought other types of employment and have been unable to support themselves and their family from a level of significant economic deprivation within the Philippines. That's their factual basis. The scenario, and as we know, when they did work abroad, they were victims of trafficking, and so what this submission seeks to articulate is to take that principle from HJ and say it cannot be correct that this is the approach of the upper tribunals and the first tier tribunal, that the appellants should avoid the risk of harm themselves by not seeking employment abroad when everybody accepts that there is what the consequences of that are going to be, but because the obligation is on them just to stay put in their serious situation where they can't afford to support themselves or their family. because seeking employment is a legitimate act, but the targeted abuse by the traffickers of certain vulnerable groups, and that's back to the definition of the PSG, whether it's broad or narrow, that is the act from which the state cannot protect or does not protect. There isn't a sufficiency of protection. And whilst Mr. Lord Murray may well go into what his Secretary of State's argument about what protection may or may not be available, I come back to my starting point, which is on the facts of this case, it was accepted that there wouldn't be such protection from that kind of trafficking, and that with the consequence there would be a real risk of harm. So the core question, I think it just, and I will reflect on it over lunch just to make sure I've articulated it correctly, is whether these women who are vulnerable to a position of, in a position where they are vulnerable to abuse of their whether these women are in a position where they are vulnerable to abuse by traffickers who are targeting them, for which the state can't protect them and which there's a constant risk of harm, whether the for which the state cannot protect them, whether that is just reflects a choice, which we say it does not, or rather an act of persecution on the part of the trafficker from which the state can't protect them. It's not a choice to seek employment, we say. It is an ordinary act of. It is an act that the appellants are entitled to undertake, and the risk arises to them not because they seek employment, but because they are targeted for abuse by traffickers.
Thank you very much. Well, it's 1 o'clock. We're going to break for lunch now. Look forward to seeing you all at 2 o'clock.